Hi everyone, Glenda back from Top Notch Legal, and I'm continuing to give a few practical tips for when you're negotiating new deals. Now, most people assume that they have to have a written document in order to have a binding contract, and that if there's nothing in writing, well, they can't be bound. But this is not so. 99% of commercial agreements do not need to be in writing in order to be enforceable. Now, it might be difficult to show what the terms of the unwritten contract are, but there still can be an enforceable contract. Now, verbal contracts are formed every day in the business world, and so you may ask, if it's not in writing, how does the court decide what the terms of the agreement are? So what the court does is it looks at all the communications and the actions of the parties, and where these align, they may well say, well, the parties showed an intention here to be bound, and that's a term of the contract. Which brings me to emails. Now, in the eyes of the law, an email is treated as a written communication, and therefore its content is very valuable in determining what the parties agreed on. And for this reason, you need to be careful in your emails. In the mind of most people, an email is like a conversation. It's something that's informal, and you don't intend to be bound by what you're saying. But that's not necessarily the case. And people go happily on exchanging emails, refining the terms of an agreement that they think they're not bound to. But that can be a trap. A contract can be formed through an email chain. And if you want to be sure that you're not going to be bound until you feel you're really ready to do so, you should include a disclaimer in those emails. And a disclaimer is just a statement saying something to the effect that we don't intend to be bound to these arrangements until we sign a formal contract, or something to that effect. And you should have this in all your emails, because otherwise it might be proven that you have taken some actions that changed the situation and reached a point where you showed that you didn't intend to be bound, and therefore you could be caught. So that's my tip for today, Glenda from Top Notch Legal.